The next case that is set for argument this morning is Peter Kuczirka versus Cecilia Ellis, D.O. It is case number 29061. Now, each party will have 15 minutes to present their arguments to the court. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve time, let me know and I'll keep you apprised of the time as you go through your argument. The arguments that are being heard are recorded and will be posted on the court's YouTube channel, so please keep your voice up and remain at the podium during the argument. We've read your briefs and we are ready to proceed if you are.
Thank you, Your Honor. Judge Hensel, Judge Teodosio, Judge Callahan. May it please the court, good morning. My name is Stacy Roth, and I have the privilege of representing the Kuczirka family in this matter. Your Honor, I probably will reserve 5 minutes for rebuttal, but I don't intend on using nearly the full amount of time. The reason being, I know this court reads the briefs. I know this is our second trip to the Court of Appeals on this very issue, and I think it would be an insult to reiterate all of the arguments that have been set forth in the briefs and reiterate all of the arguments that were made during the first time that we were here, other than to say that I'm still trying to wrap my arms around the idea that a defendant was served with a lawsuit, a complaint, obviously had notice of the lawsuit, participated for an extensive amount of time in this medical malpractice wrongful death litigation to the point where depositions were taken. We were on the eve of trial. Motions in limine had been filed, and yet the same defendant can be dismissed based solely on the method of service of the complaint. I quite frankly think the Summit County Common Pleas Order had it right. Federal Express was probably a better method of service for these lawsuits. And obviously, at some point, the Supreme Court agreed, we amended the rules. Our case is very factually distinguishable in all of these line of cases that have come through this court, in that our case was a case where service was actually attempted, which would then invoke the saving statute, which specifically says that any litigation or complaints where service was attempted is protected under the saving statute. We attempted service by demanding, in our initial complaint, I'm looking at this was in 2009. Here we are, 2018. We demanded service by certified mail. The clerk then, of course, chose Federal Express in following the Common Pleas Order. We believe under the saving statute that would qualify as an attempt of service. We also believe our action was pending at the time the amendments took place in 2012. We believe our action was pending because, in fact, and I don't want to mess anyone up on the timeline, the amendment took place July 1st of 2012. Our lawsuit was not dismissed until July 17th, 2012. At the time the amendments took place, we had defendant Ellis in the case, who did preserve their affirmative defense of failure to obtain proper service. However, at that time, for reasons that aren't clear to me, we had other defendants still in the case at the time, SUMA being one of those defendants. The SUMA defendants did in fact waive their affirmative defense of failure to obtain proper service. While we're not here to argue that failure to raise that affirmative defense applies to Dr. Ellis. What we're arguing is the fact that one of the defendants in the case had waived that offense or affirmative defense means our action was in fact pending at the time that the amendments took place, which would mean our action would then have fallen retroactively to allow that service by FedEx had been appropriate.
Counsel, when SUMA entered into the case and waived the defense, basically, because they didn't raise it like Dr. Ellis did, didn't that just, I agree with you, the case was pending, but didn't that just, for lack of a better word, or maybe the exact word, establish the commencement date of the case? So, arguably, you would have thought the case commenced when Dr. Ellis got served. If we have issue with service now, or there is issue, there's a new commencement date once SUMA answers, correct?
I believe that would have made the entire action commenced at that time.
Do you now have to start your 1 year at that point in terms of service for Dr. Ellis? I'm glad that you made clear that you're not trying to say that SUMA's waiver applied to them, because I was afraid that's what you were saying, but doesn't your 1 year kind of kick up again at the new commencement date?
I would agree, Your Honor, except for my understanding and my reading of the amendment, when they amended the civil rules, meant that it would apply retroactively to those cases then pending. So I believe at that time it would have made our case pending at the time that the amendment took place. And if nothing else, Your Honor, I think it would have made at least our argument under the saving statute stronger that a service was in fact attempted. Finally, and again, there's some case law that we've cited in our briefs that does support that when we've done everything we believe was right as far as being the plaintiff, that when there's something that was done by a clerk court or by the court itself, that should not prejudice the plaintiff. If nothing else, I would hope this court would at least adopt that theory and that practicality in the applications of the facts of this case. Because otherwise, the only party prejudiced in this case by this dismissal is the plaintiff, who is barred from pursuing any claims at this point. The defendant certainly will not be prejudiced. They have defended this case vigorously. They have experts. They will not be prejudiced by this case going to trial. And again, thank you very much for your time this morning. If there's no other questions, I don't have anything to offer.
Anything else? Okay, you'll have a full 5 minutes for rebuttal if you'd like to use it.
Thank you.
Counsel, you have 15 minutes now.
Thank you. May it please the court, my name is Doug DeLeek, and I'm here on behalf of the defendants, appellees, Dr. Ellis and her medical group. And we ask that you affirm the trial court's judgment entry, grant summary judgment. And the basis for affirming that is that the trial court properly applied stare decisis with the case law from this court, Kuczirka versus Ohio Family Center, and Suter versus Karamia. And the trial court properly concluded under these decisions that the plaintiffs did not properly commence this action because of the Federal Express service, which was not authorized under the civil rules at the time. In Kuczirka and Suter, this court provided stare decisis guidance that the amended rules, Civil Rule 4.1 through 4.6, do not apply retroactively to cure Federal Express service. In both cases, this court held that if Federal Express service was done prior to the amendments to the civil rules, that is not authorized or proper service of process. There is an exception if the court determined if the action was pending. And there's only two ways that a case could be pending for the application of the amended rules. The first one is if the amended rules became effective, authorizing Federal Express service within 1 year of commencement of the action. And in this case, this case was filed in August of 2009, and the civil rules became amended to allow Federal Express not until July 1st, 2012. beyond the 1-year period to commence an action. So that did not apply here. Second, the other way that a case could be pending is if service was then perfected the proper way within 1 year of the commencement. And here it's undisputed that that was never done in this case. So this case was not pending for the purpose of applying the amended rules that would authorize Federal Express service. The plaintiffs want you to say that Kuczirka and the Suter cases don't apply because it was the clerk that served it by Federal Express and not by their request. It is our position that the plaintiffs still had a responsibility to recognize at that time in 2009, when they got notice that there was Federal Express service, that that was improper under the civil rules. We believe it is the plaintiff's duty and responsibility to monitor the docket and recognize that, and then correct that Federal Express service at the time, but failed to do so within 1 year. Next, I'd like to address the waiver issue, and I think that's very important here. The plaintiffs want you to apply SUMA's waiver of the affirmative defense of defective service to Dr. Ellis, who properly preserved the affirmative defense. There is no dispute here that Dr. Ellis properly raised and preserved the affirmative defense of defective service of process. What I'd like to first of all, SUMA was
Aren't they
discussed.
arguing that, not that it applies necessarily to Dr. Ellis, but that it makes the action pending for the saving statute? That's the argument, isn't it?
I think that's the argument they make, and I think what we can do is we can go right to the Suter case and see that this court already addressed that issue. In Suter, at paragraph 5, you had the co-defendant, Dr. Shapiro, and his medical group. And at paragraph 5, this court recognized that Dr. Shapiro, the co-defendant, did not raise defective service as an affirmative defense. And even though the co-defendant did not raise that defective service of process, with respect to Dr. Karamian on the Federal Express issue, this court at paragraphs 11 through 16 found that Dr. Karamian preserved that defense. And then this court went further to say that the Federal Express service was ineffective and that this case was not pending. So the Suter case clears this up, that you cannot use the failure to preserve the affirmative defense by a co-defendant to say either the case was pending or that that waiver applies to the defendant who is asserting that the Federal Express was not service of process. So I believe that the Suter case disposes of that issue and that the case was not pending. And also it is not reasonable to apply that here in this case with SUMA, because SUMA was dismissed during the pendency of the first action. This case then was refiled without SUMA. And what is well known is that when a case is dismissed the first time, those pleadings in the first case become nullity. So how can the trial court in the second case use the answer of SUMA in the first case, who isn't even a party anymore? In fact, was dismissed a long time ago. So it is not possible here to use the answer of SUMA in the first filing, where they waived the affirmative defense, to the second action. So the two reasons that this case wasn't pending under this waiver issue is Suter took care of that issue. And also, you cannot use that answer of SUMA, who was dismissed in the first action, in a refiled action. And that's how this court can reject the waiver argument by the plaintiff. And with regard to the saving statute, the Ohio Supreme Court in Lynette versus Atlas Recycling has already rejected the argument made by the plaintiff here of attempted commencement of the action. At paragraph 17 of the Nev case, the Ohio Supreme Court said that in order to have attempted commencement of an action, it must be done by a proper method of service under the civil rules. And then at paragraph 18, the Ohio Supreme Court went on to say that if there was improper method of service, like here, Federal Express, there is not an attempted commencement of action, and therefore the plaintiff does not have the benefit of the savings statute. So the Nev case takes care of that attempted commencement of action. And one thing I do want to address, now that we're on the Ohio Supreme Court, is the plaintiff makes the argument that the defendant has participated in the action, done discovery, experts leading up to trial. The Ohio Supreme Court in Glioza affirmed the dismissal of a case that was raised 9 days before trial based on improper method of service. So the timing does not matter, participation in the litigation does not matter, and in the Glioza case, the Ohio Supreme Court affirmed that position. Next, the plaintiffs make the argument that under Civil Rule 86, Roman numeral 2, that the amended rules have retroactive effect. This court in Souter once again rejected that specific argument. In the Souter case, the second assignment of error was identical. It raised the Civil Rule 86-2 argument. And this court in Souter at paragraph 17 specifically says that this court does not agree that the amended rules apply retroactively. So the Civil Rule 86 Roman numeral 2 retroactive argument was also disposed of and rejected by this court in Souter. And then finally, the plaintiffs do make the argument about this being unfair. Once again, the Souter case, which came after the Kuczirka, dealt with this issue at paragraph 24 of its decision, when this court says, acknowledged, yes, you want to hear the cases on the merits, but went on to say that the civil rules are not a technicality, and you cannot ignore the civil rules to protect someone that has failed to follow those rules. So the fairness issue was taken care of by Souter once again at paragraph 24, and the trial court in this case, at page 4, did recognize this issue and said it was not unsympathetic to the plaintiff's position, and at page 4 said it was compelled to follow the precedents of Kuczirka and Souter. And I believe that the Kuczirka case sets up the Souter case, and the Souter case more expands on rejecting the arguments here with the waiver, the retroactive arguments. And on behalf of Dr. Ellis and her medical group, we ask that you affirm the summary judgment by applying stare decisis and the decisions in Kuczirka and Souter. If you don't have any questions?
All right, thank you for your argument. Attorney Roth, you have
Thank you.
5 minutes for rebuttal.
I don't really, all of the arguments that I were to make, they're in our brief. So I don't have anything further. Thank you very much.
In that case, thank you both for your presentations today and your arguments. The court will take the matter under advisement and issue a decision. The courts will, of course, mail you copies of the decision on the day it is released. You can also check the Supreme Court's website where the opinions are also posted. Once again, thank you for your excellent arguments this morning.
Thank you.